Hello everyone. This week we'll be talking about policies and programs for children and families. Kids in the U.S. are under a lot of stress. Nearly 500,000 are in foster care. The third leading cause of death for young people is suicide, and 1 in 5 are in poverty. The number of kids in poverty varies greatly by race. The graph in Chapter 9 shows how child poverty varies by race and how it has increased for all races in the past 10 years. Reducing poverty mostly means reducing poverty for the young and old, since they have the highest rates of poverty. Children are seen as a category of citizen that the state has ultimate responsibility for. When the family is not performing its function, the state becomes the parent. This doctrine is traced back to English poor law, which we covered some weeks ago. Unfortunately, the state does not do a really good job as parent. Kids in foster care are more likely to be abused, to have trouble, and to make trouble than kids who stay in their family. Of course, kids in foster care don't have a caring family to stay with right then, so there is no choice. But the quicker a kid can get back to a caring family, or to a family that cares, the better. There is one important step we could make that would reduce the number of children entering the foster care system. Poverty is a stressor for families. And when families are under financial stress, the odds of child abuse and neglect go way up. If child poverty was reduced, we would see a reduction in child abuse and neglect, and fewer kids in placement. In Tennessee, kids can come into state care through 2 systems. In the first, DCS gets involved when kids are reported to be abused or neglected. As you read in the text, the Adoption Assistance and Child Welfare Act of 1980 established family preservation as a major goal of the child welfare system. This act was an acknowledgement that kids do better overall when left with their families. The disruption itself is damaging. It is traumatic for a child to be taken from their familiar surroundings and caregivers and placed with strangers. So unless there was imminent risk, kids were more often left in the home after 1980, and the family provided support and treatment. However, it soon became clear that some families were not likely to ever rise to the level where they could care for their children. So the law was changed by the Adoption and Safe Families Act of 1997. This act allowed for speedy termination of rights in some cases, so the kids could be adopted and not spend too much time in foster care. So what we have seen over time is the swinging of the pendulum from a child-saving approach to a family preservation approach to now a hopefully more flexible policy, which tries to differentiate between families that can be rehabilitated in a reasonable time frame and families that need to be broken up so the child can be placed in a permanent caring setting. Quickly differentiating between these 2 types of families is a challenge, and it is impossible to do this without error. The second way that children come into state care is through the Department of Juvenile Justice System. In this case, kids who are arrested for a crime are placed in a justice system separate from the adult system. Juvenile crime can be a status offense, which is a special offense category that is only a crime for children, such as truancy, breaking curfew, or being incorrigible. Juvenile crime can also be an offense that would be a crime for a person of any age, such as burglary or drug possession. In both systems, DCS and DJJ, many kids are served while the kids stay with their family. And in both systems, the focus can be to help the child and family return to living without system contact as soon as possible. There is criticism of both DCS and DJJ in Tennessee. Caseloads are often too high for workers to spend much time with the child or family. Pay is low. Worker turnover is high. Paperwork requirements are driven more by legal requirements than treatment concerns. Workers who stay in these jobs are those that are dedicated to the kids and do what they can to help them within the constraints of the system. Another group of laws discussed in this chapter requires schools to provide education to all children, including those who are handicapped or disabled. The current version of this law is the Individuals with Disabilities Education Act of 1990 and 2004. Schools must now provide services to all disabled children in their district, and this is sometimes very expensive. For example, some of the new treatment regimens for autistic children can cost the school district $40,000 per child a year. And as you know, the number of autistic children is on the rise. The federal government does not give much money to local districts to pay for educating disabled students. So the federal government requires it to be done, but does not pay for all of it. The rest must be made up by the state and the local school district. So a district that by chance has a lot of handicapped kids has a special financial burden. Now consider how school vouchers for private school tuition affect this. When private schools use vouchers to take children from local schools, they also take the state and local money that goes with those students. But private schools don't have to take disabled students. So private schools take the students who are cheaper to educate and leave the more expensive disabled students to the public school, which by law cannot refuse them. This is an example of an unintended consequence of the school voucher movement. School vouchers haven't hit East Tennessee yet, but they may well soon. Perhaps that is a debate you can join when you attend the NASW Legislative Conference in March. Have a great week, everybody.